Okay, hello. Hello, magandang gabi sa inyong lahat. Muli ito si Lolo Ray para i-discuss pa rin ang Civil Code of the Philippines. Ngayon ay sisimulan na natin ang Book 2. Hopefully matapos natin Title 1 to Title 5. Okay? So Title 1 is Title 1 ng Book 2 is classification of property. Okay? Sisimula ang Book 2 sa Article 414. Okay. Article 414. All things which are or may be the object of appropriation are considered either number 1, immovable or real property, or number 2, movable or personal property. Yun po ang dalawang uri ng property sa batas. So magtungo tayo sa Chapter 1. Tatalakayin ang immovable property. Article 415. The following are immovable property. Number 1, land, buildings, roads, and constructions of all kinds adhered to the soil, o yung nakadikit kasama ng soil. Number 2, trees, plants, and growing fruits while they are attached to the land or form an integral part of an immovable. Number 3, everything attached to an immovable in a fixed manner in such a way that it cannot be separated therefrom without breaking the material or deterioration of the subject. Number 4, statues, reliefs, paintings, or other objects for use or ornamentation placed in buildings or on lands by the owner of the immovable in such a manner that it reveals the intention to attach them permanently to the tenements. Number 5, machinery, receptacles, instruments, or implements intended by the owner of the tenement for an industry or works which may be carried on in a building or on a piece of land, and which tend directly to meet the needs of the said industry or works. Number 6, animal houses, pigeon houses, beehives, fish ponds, or breeding places of similar nature, in case their owner has placed them or preserves them with the intention to have them permanently attached to the land and forming a permanent part of it. The animals in these places are included. Number 7, fertilizer actually used on a piece of land. Nailagay mo na eh. Number 8, mines, quarries, and slag dumps, while the matter thereof forms part of the bed and waters either running or stagnant. Number 9, docks and structures which, though floating, are intended by their nature and object to remain at a fixed place on a river, lake, or coast. And number 10, contracts for public works and servitudes and other real rights over immovable property. So pati pala yung kontrata for public works and servitudes ay bahagi may tuturing na immovable property. Chapter 2, movable property, Article 416. The following things are deemed to be personal property. Pwede mong dalhin kahit siya. Number 1, those movables susceptible of appropriation, pwedeng pagkakitaan, which are not included in the preceding article. Mga pwede mong bitbitin na hindi kasali sa nagdaang article. Number 2, real property which by any special provision of law is considered as personal property. Kung may batas na nag-create na ang isang lote, kunwari, personal property siya. Number 3, forces of nature which are brought under control by science. And number 4, in general, all things which can be transported from place to place without impairment of the real property to which they are fixed. Article 417, the following are also considered as personal property. Number 1, obligations and actions which have for their subject movables or demandable sums. And number 2, shares of stock of agricultural, commercial, and industrial entities, although they may have real estate. Medyo magulo, no? Pero maunamaan din natin yan. Article 418, movable properties is either consumable or non-consumable. To the first class belongs those movables which cannot be used in a manner appropriate to their nature without their being consumed. To the second class belongs all the others. So yung unang uri doon ng movable property ay yung mga property na hindi mo pwedeng hindi mo pwedeng gamitin nang hindi sila nakokonsume. At yung pangalawang uri yung ibang mga uri. Chapter 3, Property in relation to the person to whom it belongs. Article 419, property is either of public dominion or of private ownership. Okay, so dinidiscuss dito yung mga uri ng property na may kaugnayan sa taong nagmamay-ari nito. So Article 420, the following things are property of public dominion. Number 1, those intended for public use, such as roads, canals, rivers, torrents, ports, and bridges constructed by the state, banks, shores, roadsteads, and others of similar character. Number 2, those which belong to the state without being for public use and are intended for some public service or for the development of the national wealth. So kahit hindi siya ginagamit ng publiko, pero siya ay inilaan para gamitin ng publiko o sa larangan ng public service. Article 421, all other property of the state which is not of the character stated in the preceding article is patrimonial property. So pag-aralan natin anong ibig sabihin ng patrimonial para sa ating mga ordinaryong tao. Yung mga lawyers, alam na yan. Pero sa atin, ano ibig sabihin yan? Patrimonial property, ano ibig sabihin? Sabi rito, andali. Patrimonial, sabi dito, used by the state as a juridical person in its private capacity. Yun ang patrimonial property. Or all other property possessed by the local government units without prejudice to provisions of special laws. O sabi pa rito, ang example ay mga property acquired through escheat proceedings. So kunwari may isang namatay, na mayapa, wala siyang tagapagmana, kukunin ng estado ang kanyang pag-aari, yun ay escheat, gagamitin for public purpose, yun ay considered patrimonial property. Okay, so malinaw na sa atin kung ano ibig sabihin ng patrimonial property. Sandali lamang. Okay, so magpatuloy tayo. Article 422. Property of public dominion when no longer intended for public use or for public service shall form part of the patrimonial property of the state. Ayan Yung mahalaga, alam natin yung definition Article 423, the property of provinces, cities, and municipalities is divided into property for public use and patrimonial property. Article 424, property for public use in the provinces, cities, and municipalities consists of the provincial roads, city streets, municipal streets, the squares, fountains, public waters, promenades, and public works for public service paid for by said provinces, cities, or municipalities. All other property possessed by any of them is patrimonial and shall be governed by this code without prejudice to the provisions of special laws. Bigla sabihin na without prejudice, pagka merong special law, yung mga RA, special law yan, yung enacted by the Congress for a special purpose na hindi siya haharangan nitong code na ito. Kunwari, intended siya gamitin sa iba ng batas other than a patrimonial property, makapangyayari yun. Yun ang ibig sabihin ng without prejudice to the provisions of special laws. Article 425, property of private ownership besides the patrimonial property of the state, provinces, cities, and municipalities consists of all property belonging to private persons, either individually or collectively. So yung private property daw, yung hindi kasali sa pag-aari ng estado, hindi kasali sa pag-aari ng probinsya, ng city, ng munisipalidad, lahat ng pag-aari na belonging to private persons, either individually or collectively. Provisions common to the three preceding chapters. Article 426. Whenever by provision of the law or an individual declaration, the expression the expression immovable things or property or movable things or property is used, it shall be deemed to include respectively the things enumerated in chapter 1 and chapter 2. Whenever the word muebles or furniture is used alone, it shall not be deemed to include money, credits, commercial securities, stocks, and bonds, jewelry, scientific or artistic collection, books, medals, arms, clothing, horses or carriages, and their accessories, grains, liquids, and merchandise, or other things which do not have as their principal object the furnishing or ornamenting of a building, except where from the context of the law or the individual declaration the contrary clearly appears. Okay, magtungo na tayo sa Title 2 ng Book 2 ng Civil Code. Title 2 yung ownership. So Chapter 1, paliliwanag yung ownership in general. Article 427, ownership may be exercised over things or rights. So ang isang pag-aari daw ay maaaring gamitin o exercise sa isang bagay o karapatan. Article 428, the owner has the right to enjoy and dispose of a thing without other limitations than those established by law. So, pwede mo raw gamitin o kaya i-dispose ang isang bagay nang naaayon lamang sa batas. The owner has also a right of action against the holder and possessor of the thing in order to recover it. Ibig sabihin, yung may possession doon sa bagay mo, kung pag-aari mo naman yon, meron ka remedyo. Article 429, the owner or lawful possessor of a thing has the right to exclude any person from the enjoyment and disposal thereof. So, kunwari, pag gamit ko yung kotse, nasa akin, ako yung may-ari at ako yung in possession ng isang kotse, pwede kong sabihin na huwag gamitin ito ng ibang tao. For this purpose, he may use such force as may be reasonably necessary to repel or prevent an actual or threatened unlawful physical invasion or usurpation of his property. Article 430, every owner may enclose or fence his land or tenements by means of walls, ditches, live or dead hedges, or by any other means without detriment to servitudes constituted thereon. Article 431, the owner of a thing cannot make use thereof in such manner as to injure the rights of a third person. So, hindi mo naman pwedeng gamitin yung pag-aari mo para maka-injure ka ng karapatan ng ibang tao. Article 432, the owner of a thing has no right to prohibit the interference of another with the same if the interference is necessary to avert an imminent danger and the threatened damage compared to the damage arising to the owner from the interference is much greater. The owner may demand from the person benefited indemnity for the damage to him. So mahalaga yun kasi sabi rito yung may-ari ng isang bagay ay walang karapatan na pagbawalan ng pakikialam ng isang tao kung ang pakikialam na ito ay para makaiwas sa mas malaking damage. Article 433, actual possession under claim of ownership raises disputable presumption of ownership. The true owner must resort to judicial process for the recovery of the property. So yung mayroong possession daw, ang sabi niya, meron siyang presumption na pag-aari niya yun. So, yung true owner must resort to judicial process o magpunta sa korte para i-resolba ang tunay na ownership ng isang bagay. Article 434, in an action to recover the property, in an action to recover, the property must be identified and the plaintiff must rely on the strength of his title and not on the weakness of the defendant's claim. Yan So, kailangan, parang sa criminal law din yan. Kailangan, kung ikaw, similarly yung concept niyan, kung ikaw ang naghahabol o kung ikaw ang naghahabla, kailangan mag-rely ka sa lakas ng iyong ebidensya, hindi dun sa kahinaan ng depensa ng kabila. Article 435, no person shall be deprived of his property except by competent authority and for public use, and always upon payment of just compensation. Should this requirement be not first complied with, the courts shall protect and in a proper case, restore the owner in his possession. Article 436. When any property is condemned or seized by competent authority in the interest of health, safety, or security, the owner thereof shall not be entitled to compensation unless he can show that such condemnation or seizure is unjustified. Article 437. The owner of a parcel of land is the owner of its surface and of everything under it, and he can construct thereon any works or make any plantations and excavations which he may deem proper without detriment to servitudes and subject to special laws and ordinances. He cannot complain of the reasonable requirements of aerial navigation. May-ari daw ng lote, pwede niyang gawin lahat ng pwede niyang gawin doon. Pero hindi naman siya pwedeng magreklamo sa isang reasonable aerial navigation. May dumaan lang sa yung ganyan. Nagre-reklamo ka na. Article 438, hidden treasure belongs to the owner of the land, building, or other property in which it is found. So, yung hidden treasure, ang may-ari niyan, yung kung saan mo siya nakita, yung may-ari ng lokasyon kung saan mo siya nakita. Nevertheless, when the discovery is made on the property of another, or of the state or any of its subdivisions, and by chance, one half thereof shall be allowed to the finder. So, yung kalahati na yun yung finder's fee. If the finder is a trespasser, o wala siyang karapatan, di siya binigyan ng pahintulot magtungo sa property na yun, he shall not be entitled to any share of the treasure. If the things found be of interest to science of the arts, the state may acquire them at their just price, which shall be divided in conformity with the rule stated. Ayan ang rule natin sa hidden treasure. Article 439, by treasure is understood for legal purposes any hidden and unknown deposit of money, jewelry, or other precious objects, the lawful ownership of which does not appear. Okay. Walang may-ari, walang may lawful owner. Kaya, hidden treasure. Yan. Chapter 2, Right of Accession and General Provision. Article 440, the ownership of property gives the right by accession to everything which is produced thereby or which is incorporated or attached thereto, either naturally or artificially. Tungo tayo sa Section 1, Right of Accession with respect to what is produced by property. Article 441, to the owner belongs, number 1, the natural fruits, number 2, the industrial fruits, and number 3, the civil fruits. Article 442, papaliwanag niya kung ano ang natural fruits. Natural fruits are the spontaneous products of the soil and the young and other products of animals. Industrial fruits naman are those produced by lands of any kind through cultivation or labor. Civil fruits are the rents of buildings, the price of leases of lands and other property, and the amount of perpetual or life annuities or other similar income. So, malinaw na po kung ano ang natural, industrial, and civil fruits. Article 443, he who receives the fruits has the obligation to pay the expenses made by a third person in their production, gathering, and preservation. So, kunwari yung tiyuhin ko, may-ari siya ng isang manggahan, dinalan kami ng mangga rito, imbis na cash ang ibayad namin, mas yung portion ng mangga, imbis na marami yung makukuha namin, mas konti na lang yung nakukuha namin at in favor na sa kanila kasi sila yung nag-produce, nag-gather, and nag-preserve. Article 444, only such as are manifest or born are considered as natural or industrial fruits. With respect to animals, it is sufficient that they are in the womb of the mother although unborn. Okay? Malinaw yun Okay. Ang sabi rito, manifest, yung pinaghirapan lang. Ang hirap naman dun sa tenant nung lote ng tito ko. Hindi naman nila pinaghirapan kung minsan ang mangga, hindi nila inisprayan, hindi nila inalagaan, inaani lang nila. Masyado namang konti yung napupunta sa amin. Hindi na fair. Okay? Ay, nako. Anyway, okay, Section 2, right of accession with respect to immovable property. Article 445, whatever is built, planted, or sown on the land of another and the improvements or repairs made thereon belong to the owner of the land, subject to the provisions of the following articles. Okay? Article 446, all works sowing and planting are presumed made by the owner and at his expense unless the contrary is proved. Article 447, the owner of the land who makes their own, personally or through another, plantings, constructions, or works with the materials of another shall pay their value. And if he acted in bad faith, he shall also be obliged to the reparation of damages. The owner of the materials shall have the right to remove them only in case he can do so without injury to the work constructed or without the plantings, constructions, or works being destroyed. However, if the landowner acted in bad faith, the owner of the materials may remove them in any event with a right to be indemnified for damages. Article 448, the owner of the land on which anything has been built, sown, or planted in good faith shall have the right to appropriate as his own the works, sowing, or planting after payment of the indemnity provided for in Articles 546 and 548, or to oblige the one who built or planted to pay the price of the land and the one who sowed the proper rent. However, the builder or planter cannot be obliged to buy the land if its value is considerably more than that of the building or trees. In such case, he shall pay reasonable rent if the owner of the land does not choose to appropriate the building or trees after proper indemnity. The parties shall agree upon the terms of the lease, and in case of disagreement, the court shall fix the terms thereof. Kaya pagka pumapasok kayo sa lease agreement, yung pinag-usapan nyo lang, yun lang ang gagawin nyo. Huwag kayong gagawa na hindi nyo pinagpapaalam sa may-ari o hindi ninyo di nakasaad sa kontrata ninyo para walang kontrobersiya, walang problema. Article 449, he who builds, plants, or sows in bad faith on the land of another loses what is built, planted, or sown without right to indemnity. So, kunwari, meron kaming tenant. Sila yung nagbabantay doon sa bakante, doon sa lote namin. Ngayon, may mga tropa sila, nagpapainom sila doon, tumatambay sila doon sa lote namin. Ngayon, yung mga tropa nila, kunwari, nagtanim-tanim doon nang walang pahintulot sa amin, lalo na kung illegal yung tinanim o basta yung trip nila nang walang paalam sa amin. They have, pagka dumating kami doon at tinanggal namin yon, wala silang karapatan para sa indemnity. Hindi namin kailangan bayaran yun sa kanila kasi unang-una hindi mo pinaalam, ikaw ay sower in bad faith. Pangalawa, hindi ka naman tenant doon eh. Tambay ka lang doon, nagtanim ka ng gusto mo. Okay, Article 450, the owner of the land on which anything has been built, planted, or sown in bad faith may demand the demolition of the work or that the planting or sowing be removed in order to replace things in their former condition at the expense of the person who built, planted, or sowed. Or he may compel the builder or planter to pay the price of the land and the sower the proper rent. Article 451, in the cases of the two preceding articles, the landowner is entitled to damages from the builder, planter, or sower. Okay. So, entitled daw ang landowner sa damages from the builder, planter, or sower. Kung nagtayo ka ron ng in bad faith, ikaw pa magbabayad ng damages. Article 452, the builder, planter, or sower in bad faith is entitled to reimbursement for the necessary expenses of preservation of the land. Article 453, if there was bad faith, not only on the part of the person who built, planted, or sowed on the land of another, but also on the part of the owner of such land, the rights of one and the other shall be the same as though both had acted in good faith. Para bang bad faith plus bad faith equals walang kaso, pareho kayong gago eh. It is understood that there is bad faith on the part of the landowner whenever the act was done with his knowledge and without opposition on his part. Alam mo naman, tapos di ka naman nag-oppose, tapos bigla mong sisirain, o bad faith din si owner. Article 454, when the landowner acted in bad faith and the builder, planter, or sower proceeded in good faith, the provisions of Article 447 shall apply. Article 455, If the materials, plants, or seeds belong to a third person who has not acted in bad faith, the owner of the land shall answer subsidiarily for their value, and only in the event that the one who made use of them has no property with which to pay. The provision shall not apply if the owner makes use of the right granted by Article 450. If the owner of the materials, plants, or seeds has been paid by the builder, planter, or sower, the latter may demand from the landowner the value of the materials and labor. Article 456, in cases regulated in the preceding articles, good faith does not necessarily include negligence, which gives right to damages under Article 2176. Tutungo tayo sa 2176 pagkatapos ng marami pang basahin. Article 457. To the owners of lands adjoining the banks of rivers belong the accretion which they gradually receive from the effects of the current of the water. So yung may-ari ng lote, nakadikit ng mga riverbanks, yung dinadala ng tubig ng mga karagdagang lupa doon, sa'yo yun. Sa'yo yun mapupunta, according sa batas. Article 458. The owners of estates adjoining ponds or lagoons do not acquire the land left dry by the natural decrease of the waters or loose that inundated by them in extraordinary floods. Okay, ibig sabihin nun, yung may-ari ng mga lupain na malapit sa ponds or lagoons, do not acquire the land left dry by the natural decrease of waters. O, hindi naman napapasa inyo yun kung bumaba ang water level. At hindi naman din nawawala sa inyo yung mga dahil sa binaha. So, hindi naman. Article 459. Whenever the current of a river, creek, or torrent segregates from an estate on its bank a known portion of land and transfer it to another estate, the owner of the land to which the segregated portion belonged retains the ownership of it, provided that he removes the same within 2 years. Article 460. Trees uprooted and carried away by the current of the waters belong to the owner of the land upon which they may be cast, if the owners do not claim them within 6 months. If the owners do not claim them within 6 months. So, pag tinangay sa'yo ang isang puno, kunwari, nang dahil sa bagyo o baha, sa'yo na yon kung hindi i-claim ng may-ari ng punong yon sa loob ng 6 na buwan. If such owners claim them, they shall pay the expenses incurred in gathering them or putting them in a safe place. Article 461. Riverbeds which are abandoned through the natural change in the course of the waters ipso facto belong to the owners whose lands are occupied by the new course in proportion to the area lost. So, basahin natin sa ating mga layman, sa ating mga ordinaryong tao, ano ibig sabihin ng ipso facto? Ipso facto, ano ibig sabihin? By the very fact or act. Yun ang ibig sabihin nun. Ipso facto. By the very fact. So, ulitin natin. Sabi, riverbeds which are abandoned through the natural change in the course of the waters, by the very fact, belong to the owners whose lands are occupied by the new course in proportion to the area lost. Okay? So, kunwari, iba na ang course ng tubig, nagkaroon ng baha, na-ocupa na, dinaanan na ng tubig yung ari-arian mo. Yung iniwanan niya na hindi niya na dinadaanan, yun ang kapalit. Yun ang automatic, sa'yo na yun. Article, however, the owners of the lands adjoining the old bed shall have the right to acquire the same by paying the value thereof, which value shall not exceed the value of the area occupied by the new bed. Okay? So, yung may-ari daw, kunwari, hindi na dito dumadaan yung tubig, dinaanan yung lote mo. So, ito na yung sayo ngayon. Kaso may katabing lote, may may-ari. Yung may-ari, babayaran niya sa'yo yung area na yun. Gets? Article 462. Whenever a river changing its course by natural causes opens a new bed through a private estate, this bed shall become of public dominion. Ibig sabihin ng bed rito, hindi kama ha, yung daanan ng tubig. Article 463. Whenever the current of a river divides itself into branches, leaving a piece of land or part thereof isolated, the owner of the land retains his ownership, period. He also retains it if a portion of land is separated from the estate by the current. Article 464. Islands which may be formed on the seas within the jurisdiction of the Philippines, on lakes, and on navigable or floatable rivers belong to the state. Okay, estado ang may-ari yan. Article 465. Islands which through successive accumulation of alluvial deposits are formed in non-navigable and non-floatable rivers belong to the owners of the margins or banks nearest to each of them, or to the owners of both margins if the island is in the middle of the river, in which case it shall be divided longitudinally in halves. Latitude, tama ba? Latitude, longitude. If a single island thus formed be more distant from one margin than from the other, the owner of the nearer margin shall be the sole owner thereof. Section 3, Title 2 pa rin tayo, Right of Accession with respect to movable property. Article 466, whenever two movable things belonging to different owners are without bad faith, united in such a way that they form a single object, the owner of the principal thing acquires the accessory, indemnifying the former owner thereof for its value. Okay, so pag may dalawa raw na movable things belonging to different owners, walang bad faith, united, nagsama sila in a way that they form a single object, the owner of the principal thing acquires the accessory, indemnifying the former. So yung may-ari ng principal thing, sumama yung mas maliit, sa kanya na rin yung accessory na yun, pero babayaran niya yung may-ari ng accessory thing. Article 467, the principal thing as between two things incorporated is deemed to be that to which the other has been united as an ornament or for its use or perfection. Article 468, if it cannot be determined by the rule given in the preceding article which of the two things incorporated is the principal one, di mo alam kung saan doon yung principal thing, the thing of the greater value shall be considered, and as between two things of equal value, that of the greater volume. In painting and sculpture, writings, printed matter, engraving, and lithographs, the board, metal, stone, canvas, paper, or parchment shall be deemed the accessory thing. Ayan, naman naintindihan na natin nung sinabi niya yung engraving, printed matter, ayan. Article 469, whenever the things united can be separated without injury, their respective owners may demand their separation. Basta hindi masisira yung yung property na yon. Nevertheless, in case the thing united for the use, embellishment, or perfection of the other is much more precious than the principal thing, the owner of the former may demand its separation, even though the thing to which it has been incorporated may suffer some injury. Article 470, whenever the owner of the accessory thing has made the incorporation in bad faith, he shall lose the thing incorporated and shall have the obligation to indemnify the owner of the principal thing for the damages he may have suffered. If the one who has acted in bad faith is the owner of the principal thing, the owner of the accessory thing shall have a right to choose between the former paying him its value or that the thing belonging to him be separated, even though for this purpose it be necessary to destroy the principal thing, and in both cases, furthermore, there shall be indemnity for damages. If either one of the owners has made the incorporation with the knowledge and without the objection of the other, their respective rights shall be determined as though both acted in good faith. Article 471, whenever the owner of the material employed without his consent has a right to an indemnity, he may demand that this consist in the delivery of a thing equal in kind and value, and in all other respects to that employed, or else in the price thereof, according to expert appraisal. Okay. Article 472, if by the will of their owners, two things of the same or different kinds are mixed, or if the mixture occurs by chance, and in the latter case the things are not separable without injury, each owner shall acquire a right proportional to the part belonging to him, bearing in mind the value of the things mixed or confused. Okay, mga nag-mix-mix na mga, kunwari, alak. Na-mix yung alak. Mainit ah. Article 473, if by the will of only one owner but in good faith, two things of the same or different kinds are mixed or confused, the right of the owner shall be determined by the provisions of the preceding o ng nagdaang article. If the one who caused the mixture or confusion acted in bad faith, he shall lose the thing belonging to him thus mixed or confused, besides being obliged to pay indemnity for the damages caused to the owner of the other thing with which his own was mixed. Mixture na. Article 474. One who, in good faith, employs the material of another in whole or in part in order to make a thing of a different kind, shall appropriate the thing thus transformed as his own, indemnifying the owner, babayaran mo yung owner, of the material for its value. If the material is more precious than the transformed thing or is of more value, its owner may, at his option, appropriate the new thing to himself after first paying indemnity for the value of the work or demand indemnity for the material. If, in the making of the thing, bad faith intervened, the owner of the material shall have the right to appropriate the work for himself without to himself without paying anything to the maker, or to demand of the latter that he indemnify him for the value of the material and the damages he may have suffered. However, the owner of the material cannot appropriate the work in case the value of the latter, for artistic or scientific reasons, is considerably more than that of the material. Article 475, in the preceding articles o sa mga nagdaang articles, sentimental value shall duly be appreciated. So, wag natin minamaliit yung sentimental value. May value siya. Hindi lamang sa atin. Hindi lamang sa taong nagbibigay ng sentimental value sa kanya. Meron din siyang value. It shall be appreciated under the Civil Code. Chapter 3, Quieting of Title. O ito, may mga nagpe-petition ito, quieting of title. Merong cloud o may kaguluhan doon sa titulo mo. Article 476, whenever there is a cloud on title to real property or any interest therein, by reason of any instrument, record, claim, encumbrance, or proceeding which is apparently valid or effective but is in truth and in fact invalid, ineffective, voidable, or unenforceable and may be prejudicial to said title, an action may be brought to remove such cloud or to quiet the title. Ito yung action for quieting of the title or removing the cloud. An action may also be brought to prevent a cloud from being cast upon title to real property or in any interest therein. Meron pong nag-aano nito, nag-actual na nangyayari ito talaga. Article 477, the plaintiff must have legal or equitable title to or interest in the real property which is the subject matter of the action. He need not be in possession of said property. Hindi naman kailangang hawak niya, basta siya ay may legal or equitable title. Okay. Article 478, there may also be an action to quiet title or remove a cloud therefrom when the contract, instrument, or other obligation has been extinguished or has terminated or has been barred by extinctive prescription. Article 479, the plaintiff must return to the defendant all benefits he may have received from the latter or reimburse him for expenses that may have redounded to the plaintiff's benefit. Article 480, the principles of the general law of the quieting of title are hereby adopted insofar as they are not in conflict with this code. Article 481, the procedure for the quieting of title or the removal of the cloud therefrom shall be governed by such rules of court as the Supreme Court shall promulgated. Nasa rules natin, hindi ko lang matandaan kung saan doon. Civil procedure siguro, or special proceedings, hindi ko na alam. Special proceedings yata. Chapter 4, ruinous buildings and trees in danger of falling. Article 482, if a building, wall, column, or any other construction is in danger of falling, the owner shall be obliged to demolish it or to execute the necessary work in order to prevent it from falling. If the proprietor does not comply with this obligation, The administrative authorities may order the demolition of the structure at the expense of the owner or take measures to ensure public safety. Article 483. Whenever a large tree threatens to fall in such a way as to cause damage to the land or tenement of another or to travelers over a public or private road, the owner of the tree shall be obliged to fell and remove it. Siya ang dapat magputol noon at magtanggal noon. And should he not do so, it shall be done at his expense by order of the administrative authorities. Okay. So yung pag-aari kunwari ng vicinity ng simbahan, sila yung may obligasyong magtanggal ng mga malalaking nara nila na kung ito naman ay makakasagabal, di ba? O sandali lang, break muna tayo at pupunta na tayo sa Title 3. Okay. Okay, magtungo na tayo sa Title 3. Co-ownership. Okay. Sisimula ang Title 3 of Book 2 ng Civil Code sa Article 484. There is co-ownership whenever the ownership of an undivided thing or right belongs to different persons. In default of contracts or of special provisions, co-ownership shall be governed by the provisions of this title. Article 485. The share of the co-owners in the benefits as well as in the charges shall be proportional or hati to their respective interests. O kunwari, 80% ang dinonate ko, 20% sa partner ko, 80-20 kami. Any stipulation in a contract to the contrary shall be void. The portions belonging to the co-owners in the co-ownership shall be presumed equal unless the contrary is proved. Okay? Presumption ng partnership, equal kayo. Article 486. Each co-owner may use the thing owned in common, provided he does so in accordance with the purpose for which it is intended and in such a way as not to injure the interest of the co-ownership or prevent the other co-owners from using it according to their rights. The purpose of the co-ownership may be changed by agreement, express or implied. Article 487. Any one of the co-owners may bring an action in ejectment. Okay? So kahit na sino sa kanila, pwede siyang mag-bring an action in ejectment. Article 488. Each co-owner shall have a right to compel the other co-owners o pilitin sila to contribute to the expenses of preservation of the thing or right owned in common and to the taxes. So kunwari, yung mga magkakapatid, kumikita, hati-hati sila, kunwari, 12 sila magkakapatid. Co-owners sila ng isang ari-arian na kumikita. Yung share nila na yun, pwede nilang pilitin na, uy, mag-contribute kayo at ipapagawa natin ito, i-repair natin ito, babayad tayong buwis. So kung tag-1,000 ang nakukuha ninyo buwan-buwan, maglaan kayo ng tig 200 pesos para sa pagbabayad ng buwis at sa pagre-repair nito. Ganun po. Ganun po yun ha. Hindi yung laging puro gulangan. Parehas naman. Isa naman yung pinagkakakitaan ha. May ganun. Any one of the latter may exempt himself from this obligation by renouncing so much of his undivided interest as may be equivalent to his share of the expenses and taxes. No such waiver shall be made if it is prejudicial to the co-ownership. Walang waiver na pwedeng gawin kung ito ay hindi makakaganda sa co-ownership. Article 489. Repairs for preservation may be made at the will of one of the co-owners, but he must, if practicable, first notify his co-owners of the necessity of such repairs. Expenses to improve or embellish the thing shall be decided upon by a majority as determined in Article 492. Article 490. Whenever the different stories of a house belong to different owners, if the titles of ownership do not specify the terms under which they should contribute to the necessary expenses, and there exists no agreement on the subject, the following rules shall be observed. Number 1, The main and party walls, the roof, and the other things used in common shall be preserved at the expense of all the owners in proportion to the value of the story belonging to each. Number 2, each owner shall bear the cost of maintaining the floor of his story, the floor of the entrance, front door, common yard, and sanitary works common to all shall be maintained at the expense of all the owners pro rata. Bago natin ituloy, para sa ating mga layman, ano ibig sabihin ng pro rata? Hindi naman lahat sa atin nakakaalam yan. Pro rata. Ibig sabihin ng pro rata ay proportional. Okay? So malinaw ha. Nakalagay sa batas na kailangan uh, yung expenses ng sanitary works, pag-aayos shall be pro rata. Ha? Number 3, or proportional to your share. Hindi naman ibig sabihin laging 50-50. Kunwari nga, doon sa una kong example, 80% ang kinontribute ko sa partnership, 20% sa kanya, so 80-20, ganon. Number 3, the stairs from the entrance to the first story shall be maintained at the expense of all owners pro rata or proportional, with the exception of the owner of the ground floor. The stairs from the first to the second story shall be preserved at the expense of all, except the owner of the ground floor and the owner of the first story, and so on successively. Article 491. None of the co-owners shall, without the consent of the others, make alterations in the thing owned in common, even though benefits for all would result therefrom. However, if the withholding of the consent by one or more of the co-owners is clearly prejudicial to the common interest, the courts may afford adequate relief. Article 492. For the administration and better enjoyment of the thing owned in common, the resolutions of the majority of the co-owners shall be binding. There shall be no majority unless the resolution is approved by the co-owners who represent the controlling interest in the object of the co-ownership. Should there be no majority, or should the resolution of the majority be seriously prejudicial to those interested in the property owned in common, the court, at the instance of an interested party, shall order such measures as it may deem proper, including the appointment of an administrator. So, kunwari, 12 kami magkakapatid, hindi pa kami magkasundo-sundo. Equally kami, kunwari, 6 ang bumoto, 16 o hindi. Doon na lang tayo sa kung ano yung makakabuti. At pupunta ka pa sa korte para kumuha ng administrator, di ba? So, wala namang masamang magkasundo. Pag-usapan nang hindi nag-aaway. Whenever a part of the thing belongs exclusively to one of the co-owners, the remainder is owned in common. The preceding provision shall apply only to the part owned in common. Article 493. Each co-owner shall have the full ownership of his part and of the fruits and benefits pertaining thereto, and he may therefore alienate, assign, or mortgage it, and even substitute another person in its enjoyment, except when personal rights are involved. But the effect of the alienation or the mortgage with respect to the co-owners shall be limited to the portion which may be allotted to him in the division upon the termination of the co-ownership. Article 494. No co-owner shall be obliged to remain in the co-ownership, period. Each co-owner may demand at any time the partition of the thing owned in common, insofar as his share is concerned. Nevertheless, an agreement to keep the thing undivided for a certain period of time, not exceeding 10 years, shall be valid. This term may be extended by a new agreement, period. A donor or testator may prohibit partition for a period which shall not exceed 20 years. Neither shall there be any partition when it is prohibited by law. No prescription shall run in favor of a co-owner or co-heir against his co-owners or co-heirs so long as he expressly or impliedly recognizes the co-ownership. Article 495. Notwithstanding the provision of the preceding article, the co-owners cannot demand the physical division of the thing owned in common, when to do so would render it unserviceable for the use for which it is intended. But the co-ownership may be terminated in accordance with Article 498. Article 496. Partition may be made by agreement between the parties or by judicial proceedings. So, ang payo ko sa inyo, agree na lang kayo. Partition shall be governed by the rules of court insofar as they are consistent with this code. Okay? Kailangan alinsunod. Basta consistent yung nakalagay sa rules ng pagpapartition dito, sinasabi dito. Article 497, the creditors or assignees of the co-owners may take part in the division of the thing owned in common and object to it being affected without their concurrence. Kasi nga naman, may interest sila creditor sila or assignees sila ng karapatan But they cannot impugn o kontrahen any partition already executed unless there has been fraud or in case it was made notwithstanding a formal opposition presented to prevent it without prejudice to the right of the debtor or assignor to maintain its validity. Article 498, whenever the thing is essentially indivisible and the co-owners cannot agree that it be allotted to one of them who shall indemnify the others, it shall be sold and its proceeds distributed. Article 499, the partition of a thing owned in common shall not prejudice third persons who shall retain the rights of mortgage, servitude, or any other real rights belonging to them before the division was made. Personal rights pertaining to third persons against the co-ownership shall also remain in force, notwithstanding the partition. Article 500, upon partition, there shall be a mutual accounting for benefits received and reimbursements for expenses made. Likewise, each co-owner shall pay for damages caused by reason of his negligence or fraud. Article 501, every co-owner shall after partition, masyado ako mabilis. Article 501, every co-owner shall, after partition, be liable for defects of title and quality of the portion assigned to each of the other co-owners. Okay? Malinaw. Tungo na tayo sa Title 4 of Book 2 of the Civil Code of the Philippines. Title 4, some special properties. Section 1, yung ownership of waters. Article 502, the following are of public dominion. Okay. Number 1, rivers and their natural beds. Number 2, continuous or intermittent waters of springs and brooks running in their natural beds and the beds themselves. Number 3, waters rising continuously or intermittently on lands of public dominion. Number 4, lakes and lagoons formed by nature on public lands and their beds. Number 5, rainwaters running through ravines or sand beds which are also of public dominion. Number 6, subterranean waters on public lands. Number 7, waters found within the zone of operation of public works even if constructed by a contractor. Number 8, waters rising continuously or intermittently on lands belonging to private persons, to the state, to a province, or to a city or a municipality from the moment they leave such lands. Number 9, wastewaters of fountains, sewers, and public establishments. Article 503, the following are of private ownership. Ito naman yung mga tubig na pag-aari ng private, ng pribadong nilalang. Number 1, continuous or intermittent waters rising on lands of private ownership while running through the same. Number 2, lakes and lagoons and their beds formed by nature on such lands or such private lands. Number 3, subterranean waters found on the same. Number 4, rainwaters falling on said lands as long as they remain within the boundaries. Number 5, the beds of flowing waters, continuous or intermittent, formed by rainwater and those brooks crossing lands which are not of public dominion. In every drain or added aqueduct, the water bed, banks, and floodgates shall be considered as an integral part of the land of building for which the waters are intended. The owners of lands through which or along the boundaries of which the aqueduct passes cannot claim ownership over it or any right to the use of its bed or banks unless the claim is based on titles of ownership specifying the right of ownership claimed. Hindi na masyadong pinag-uusapan itong mga waters na to Okay? Pero basahin pa rin natin iba. Sabi dito sa Article 515, the owner of a piece of land on which there are defensive works to check waters or on which, due to a change of their course, it may be necessary to reconstruct such works, shall be obliged at his election, either to make the necessary repairs or construction himself, or to permit them to be done without damage to him by the owners of the lands which suffer or are clearly exposed to suffer injury. Ayan ah. Okay. Oh, basahin natin minerals. Waters, basa na natin minerals. Article 519, mining claims and rights and other matters concerning minerals and mineral lands are governed by special laws. Kasi merong special law, merong RA or something na binuo para sundan ng mga nagmimina. Chapter 3, trademarks and trade names. Article 520, a trademark or trade name duly registered in the proper government bureau or office is owned by and pertains to the person, corporation, or firm registering the same, subject to the provisions of special laws. Article 521, the goodwill of a business is property. It may be transferred together with the right to use the name under which the business is conducted. Article 522, trademarks and trade names are governed by special laws. Merong intellectual property law yata yan eh. Para bang Lolo Ray. Yan ang isa sa aking mga trade name. Okay? Ito nga tayo sa Title 5, Possession. Mahaba-haba ito. Chapter 1, Possession and the kinds thereof. Article 523, possession is the holding of a thing or the enjoyment of a right. Tulad nito, holding of a thing, enjoyment of a right. Yun yung possession. Article 524, possession may be exercised in one's own name or in that of another. Okay. Pwede mo namang i-possess. Like ako, yung kotse ko, nakapangalan sa tatay ko. Possession, nasa ibang pangalan ng tatay ko, pero in my possession. Article 525, the possession of things or rights may be had in one of two concepts, either in the concept of owner or in that of the holder of the thing or right to keep or enjoy it, the ownership pertaining to another person. Article 526, he is deemed a possessor in good faith who is not aware that there exists in his title or mode of acquisition any flaw which invalidates it. He is deemed a possessor in bad faith who possesses in any case contrary to the foregoing. So, linawin natin to. Ang possessor in good faith, hindi siya aware that there exists in his title or mode of acquisition any flaw which invalidates it. So, kunwari ito, binili to, hindi ko alam na nakaw siya. Binili ko siya sa isang lehitimong tindahan. So, good faith ako. Contrary to that, bad faith yan. Kaya nga may anti-fencing law, di ba? Krimen na yun, yung bibili ka ng nakaw. Kasi possessor in bad faith ka na nun. Mistake upon a doubtful or difficult question of law may be the basis of good faith. Article 527, good faith is always presumed, and upon him who alleges bad faith on the part of a possessor rests the burden of proof. So kung nag-allege ka na bad faith, ikaw ang dapat na mag-prove. Para mga pulis, huli nila ang isang tao, may krimen, sila ang dapat na mag-prove. Okay. Kagaya ng pinag-usapan natin kanina, the burden shall be doon sa lakas ng iyong ebidensya, hindi sa weakness ng defense. Article 528, possession acquired in good faith does not lose this character, except in the case and from the moment facts exist which show that the possessor is not unaware that he possesses the thing improperly or wrongly. Okay, Article 529, it is presumed that possession continues to be enjoyed in the same character in which it was acquired until the contrary is proved. Hanggang sa di mo napapatunayan, it is presumed. Article 530, only things and rights which are susceptible of being appropriated may be the object of possession. Okay. Para linawin natin, susceptible of being appropriated. Ano ba ang tunay na kahulugan ng appropriated? Susceptible of appropriate. Ayan. Tingnan natin ibig sabihin. Para malinaw, ibig sabihin, take something for one's own use. Typically without the owner's permission. So, yun ang ibig sabihin ng appropriate. Take something for one's own use. So yan malinaw mga kalolore So only the things and rights which are susceptible of being taken for one's own use may be the object of possession. Tulad nito, diba? It is susceptible for taken for one's own use or susceptible of being appropriated. Chapter 2, Acquisition of Possession. Article 531, possession is acquired by the material occupation of a thing or the exercise of a right, or by the fact that it is subject to the action of our will, or by the proper or by the proper action, legal formalities established for acquiring such right. Article 532, possession may be acquired by the same person who is to enjoy it by his legal representative, by his agent, or by any person without any power whatever. But in the last case, the possession shall not be considered as acquired until the person in whose name the act of possession was executed has ratified the same without prejudice to the judicial consequences of negotiorium gestio in a proper case. So alamin natin ang ibig sabihin ng negotiorium gestio. Alam ko ito yung basta alam ko 'to sa ano 'to sa negotiable contract. As obligations and contract. Negotiorium gestio para alam nating mga laymans. Ibig sabihin nito ay Wikipedia na lang tayo. Is a form of spontaneous voluntary agency in which an intervener may nakialam or intermeddler. The gestor acts on behalf and for the benefit of the principal but without the latter's prior consent. So, ang isang mahalagang example dito ay kunwari, wala akong pahintulot pero ikaw nakita mong nagsusuka yung aso ko, binigyan mo ng asukal galing sa'yo, binigyan mo ng asukal tapos as a result, naisuka niya yung lason. May karapatan kang magsingil sa akin na, hoy, binigyan ko ng asukal yung aso mo, bayaran mo yung asukal ko. Okay? Yun ang konsepto ng negotiorium gestio. Okay, malinaw Article 533, the possession of hereditary property is deemed transmitted to the heir without interruption and from the moment of the death of the decedent, nung namatay na yung may-ari ng ari-arian, in case the inheritance is accepted. One who validly renounces o hindi niya tinanggap, pinawalang bisa niya yung inheritance, is deemed never to have possessed the same. Okay? Bakit ko naman ipapawalang bisa yung aking inheritance? Sayang naman. Lalo naman kung ang na-inherit mo ay good looks. Charot. Article 534, on who succeeds by hereditary title shall not suffer the consequences of the wrongful possession of the decedent if it is not shown that he was aware of the flaws affecting it. But the effects of possession in good faith shall not benefit him except from the date of the death of the decedent. Article 535, minors and incapacitated persons may acquire the possession of things, but they need assistance of their legal representatives in order to exercise the rights which from the possession arise in their favor. Article 536, in no case may possession be acquired through force or intimidation as long as there is a possessor who objects thereto. So, bawal ka raw mag-possess through force or intimidation. Bawal yun. He who believes that he has an action or right to deprive another of the holding of a thing must invoke the aid of the competent court if the holder should refuse to deliver the thing. Okay, pag ayaw, korte mo na lang para safe. Article 537, acts merely tolerated and those executed clandestinely and without the knowledge of the possessor of a thing or by violence do not affect possession. So, tinolerate lang. Hinayaan ka lang dyan. Di ibig sabihin sa'yo na yan. Okay? Article 538, possession as a fact cannot be recognized at the same time in two different personalities except in the cases of co-possession. Should a question arise regarding a fact of possession, the present possessor shall be preferred if there are two possessors, the one longer in possession, if the dates of the possession are the same, the one who presents the title, and if all these conditions are equal, the thing shall be placed in judicial deposit pending determination of its possession or ownership through proper proceedings. Ang ginagamit yata rito yung replevin, kung di ako nagkakamali. Okay, so yung pinag-aawayan yung bagay, dun muna. Deposit muna natin sa court. Ngitan ako bigla. Okay, Chapter 3, Effects of Possession, Article 539. Every possessor has a right to be respected in his possession, and should he be disturbed therein, he shall be protected in or restored to said possession by the means established by the laws and the rules of court. A possessor deprived of his possession through forcible entry may, within 10 days from the filing of the complaint, present a motion to secure from the competent court in the action for forcible entry a writ of preliminary mandatory injunction to restore him in his possession. The court shall decide the motion within 30 days from the filing thereof. Article 540. Only the possession acquired and enjoyed in the concept of owner can serve as a title for acquiring dominion. Okay? Sabi dito, yung possession acquired and enjoyed in the concept of owner, yung parang ikaw yung may-ari, can serve as a title for acquiring dominion. Para sa ating layman, ano ibig sabihin ng dominion? Dominion. Okay, ano ibig sabihin ng dominion? Sovereignty or control. Ayan malinaw ang ibig sabihin ng dominion. Sovereignty or control. So, only the possession acquired and enjoyed in the concept of owner can serve as title for acquiring dominion o yung control. Article 541, a possessor in the concept of owner has in his favor the legal presumption that he possesses with a just title and he cannot be obliged to show or prove it. Article 542, the possession of real property presumes that of the movables therein, so long as it is not shown or proved that they should be excluded. Okay? Article 543, each one of the participants of a thing possessed in common shall be deemed to have exclusively possessed the part which may be allotted to him upon the division thereof for the entire period during which the co-possession lasted. Interruption in the possession of the whole or part of a thing possessed in common shall be to the prejudice of all possessors. Makakasama, makakaperwisyo o harang na yun sa mga possessors yung interruption in the possession of the whole or a part of the thing. However, in case of civil interruption, the rules of court shall apply. Okay. Article 544, a possessor in good faith is entitled to the fruits received before the possession is legally interrupted. Natural and industrial fruits are considered received from the time they are gathered or severed. Civil fruits are deemed to accrue daily and belong to the possessor in good faith in that proportion. So, alam na natin yung civil fruits, yung mga renta, yan. Article 545, if at the time the good faith ceases, there should be any natural or industrial fruits, the possessor shall have right to a part of the expenses of cultivation and to a part of the net harvest, both in proportion to the time of the possession. The charges shall be divided on the same basis by the two possessors. The owner of the thing may, should he so desire, give the possessor in good faith the right to finish the cultivation and gathering of the growing fruits as an indemnity for his part of the expenses of cultivation and the net proceeds. The possessor in good faith who, for any reason, whatever, should refuse to accept this concession, shall lose the right to be indemnified in any other manner. Kung ayaw mong makipag-areglo, hindi man areglo yung term, pero binibigyan ka na nga ng kasunduan, ayaw mo dito sa legal na kasunduan na sinasaad dito, you shall not be indemnified o hindi ka babayaran in any other manner. Pumaparehas na nga, ayaw mo pa. Article 546, necessary expenses shall be refunded to every possessor, but only the possessor in good faith may retain the thing until he has been reimbursed therefor. Useful expenses shall be refunded only to the possessor in good faith with the same right of retention, the person who has defeated him in the possession having the option of refunding the amount of the expenses or of paying the increase in value which the thing may have acquired by reason thereof. Article 547. If the useful improvements can be removed without damage to the principal thing, the possessor in good faith may remove them unless the person who recovers the possession exercises the option under paragraph 2 of the preceding article. Article 548. Expenses for pure luxury or mere pleasure shall not be refunded to the possessor in good faith, but he may remove the ornaments with which he has embellished the principal thing if it suffers no injury thereby, and if his successor in the possession does not prefer to refund the amount expended. Article 549. The possessor in bad faith shall reimburse the fruits received and those which the legitimate possessor could have received, and shall have a right only to the expenses mentioned in paragraph 1 of Article 546 and in Article 443. So kung ikaw, possessor ka in bad faith, sa huli mo, re-reimburse mo yung fruits na natanggap mo na dapat ay natanggap ng legitimate possessor. The expenses incurred in improvements for pure luxury or mere pleasure shall not be refunded to the possessor in bad faith, but he may remove the objects for which such expenses have been incurred, provided that the thing suffers no injury thereby and that the lawful possessor does not prefer to retain them by paying the value they may have at the time he enters into possession. Article 550. The costs of litigation over the property shall be borne by every possessor, o yung gastos ng litigation over a property ay gastos ng every possessor. Article 551. Improvements caused by nature or time shall always ensure to the benefit of the person who has succeeded in recovering possession. Article 552. A possessor in good faith shall not be liable for the deterioration or loss of the thing possessed, except in cases in which it is proved that he has acted with fraudulent intent or negligence after the judicial summons. A possessor in bad faith shall be liable for deterioration or loss in every case, even if caused by a fortuitous event. Article 553. One who recovers possession shall not be obliged to pay for improvements which have ceased to exist at the time he takes possession of the thing. Okay? Yung naka-recover ng possession, hindi siya obligadong magbayad ng improvements which have ceased to exist at the time it takes possession of the thing. Article 554. A present possessor who shows his possession at some previous time is presumed to have held possession, although also during the intermediate period in the absence of proof to the contrary. Article 555. A possessor may lose his possession, number 1, by the abandonment of the thing, number 2, by an assignment made to another, either by onerous or gratuitous title, number 3, by the destruction or total loss of the thing, or because it goes out of commerce, number 4, by the possession of another, subject to the provision of the Article 537, if the new possession has lasted longer than 1 year, but the real right of possession is not lost till after the lapse of 10 years. So, para hindi natin makalimutan, ibig sabihin ng onerous, yung example na binigay ko kahapon, yung kunwari, si Pedro, binigay niya ako ng lupa para tayuan ko ng negosyo at kumita ang negosyo ko, umasenso ako. In return, bumili ako ng luxury car na mas mahal pa sa lupa na binigay sa akin ni Pedro at iniregalo ko sa kanya. Yun po ang ibig sabihin ng onerous donation. Onerous donation. Or gratuitous title. Ibig sabihin ng gratuitous, walang kapalit. Okay? Article 556, binigay na walang kapalit. The possession of movables is not deemed lost so long as they remain under the control of the possessor, even though for the time being he may not know their whereabouts. Article 557, the possession of immovables and of real rights is not deemed lost or transferred for purposes of prescription to the prejudice of third persons, except in accordance with the provisions of the mortgage law and the land registration laws. Okay? Article 558, acts relating to possession, executed or agreed to by one who possesses a thing belonging to another, as a mere holder to enjoy or keep it, in any character do not bind or prejudice the owner, unless he gave said holder express authority to do so, to do such acts, or ratifies them subsequently. Ibig sabihin ng ratify, inaprobahan. Article 559. The possession of movable property acquired in good faith is equivalent to a title. Nevertheless, one who has lost any movable or has been unlawfully deprived thereof may recover it from the person in possession of the same. If the possessor of a movable lost or which the owner has been unlawfully deprived has acquired it in good faith at a public sale, the owner cannot obtain its return without reimbursing the price paid therefor. Article 560. Wild animals are possessed only while they are under one's control. Domesticated or tamed animals are considered domestic or tame if they retain the habit of returning to the premises of the possessor. Okay? So, hindi mo pwedeng gamitin itong dahilan naman kung ninakaw mo yung kalabaw niya. Yung kalabaw niya, hindi naman naalis doon kung hindi mo pinastol palayo. So, hindi mo pwedeng gamitin ito, ha? O, babalik yung hayop na regular naman bumabalik. Kung hindi mo ninakaw o hindi mo sinira yung bakod at pinalabas siya, magnanakaw ka. Iba yun, ha? Article 561. One who recovers according to law, possession unjustly lost, shall be deemed for all purposes which may redound to his benefit to have enjoyed it without interruption. So, dyan po nagtatapos ang ating live ngayong gabi, ang ating pagbabasa ng Civil Code. So, natapos natin from Title, Civil Code Book 2, Title 1 to Title 5. Next time, magbabalik tayo para basahin ng Title 6, hopefully hanggang Title 9. So, dyan nagtatapos Title 1 to Title 5 of Book 2 ng Civil Code. Sana'y nag-enjoy kayo at sana'y samahan nyo ako muli. Samahan nyo muli sa isa na namang edisyon ng In Layman's Terms. Saan magbabasa lang tayo ng batas at susubukan natin ipaliwanag in layman's term. Ako nga pala si Lolo Ray. Good night and God bless.